talk about this topic, but I feel it's very important to be educated at least about options that you have. We know that the H1B registration has just kickstarted not long ago. And then as I was just talking to Attorney Main about how busy it gets during the season, and then definitely some people, not all people are opted in into the H1B lottery right away. Some people are still figuring out their career opportunity. Some people might be joining us from the call that you're still in school. We're letting in 1 more minute before everybody joining in. But our point is that we wanted to um, let you guys be educated about the options of the self-sponsorship. You might heard that things have changed. It used to be like a gray area or something that is almost impossible to do, but right now you actually have rules that supports it. Is actually legitimate, and then a lot of people are starting to doing it. Looking from the attorney point of view, but also looking from like entrepreneurship point of view as well. So for those of you who are wondering, if I don't have a sponsor, if I couldn't get into the H1B lottery for now, is it possible for me to self-sponsor myself to get in? If not this year, maybe even next year, if I my OPTs, maybe I have 3 years, how could I plan accordingly? And if there's any rules that are benefiting me to be able to make that move that I couldn't maybe do it 2 years ago or 3 years ago. So today is all about that topics. And then feel free to, if you come in with the questions, definitely take advantage of the Q&A box. You will have two box down below. One is the Q&A, and then one is the chat function. Make sure that you utilize the Q&A. You can send in your questions, and then we will have a half session dedicated just to live questions with our guest attorney Maine today. I wanted to give a warm welcome to attorney Marta Maine. She has been working with us for a long time. She's a very knowledgeable expert immigration attorney. And then she is the managing attorney in Maine Law Group based in Los Angeles. Attorney Maine, do you want to go ahead and introduce yourself just a little bit?
Sure. Thank you, Ryan. Hi, good afternoon, everybody. My name is Marta Mann. As Ryan mentioned, I practice immigration law. I have been practicing for 13 years now. So my specialty is in work visas and all kinds of employment-based petitions. So I would be happy to share with you what I have observed in the past year about beneficiary owner H1Bs. So this is a new thing that is something started being implemented from the H1B modernization rule, which was released January 2025. So that was the rule published by the last administration. And the current administration is still implementing it. So the current administration is not taking back this rule. So we're still seeing these cases being processed at USCIS. So I would be happy to share with you, are they hard to be approved, or what are the things we should watch out for when we are filing those petitions?
Mhm. Absolutely. Thank you for your introduction. And then right now we see already a lot of people rolling in. So, and then as Marta, you already talked about the subject for today. I wouldn't bore you guys with the details. We'll jump right into that. Before we do that, just wanted to talk about who we are and why we're here today. So, as the host, we are Go Elite, and we are an education consultancies, mainly work with CPT, hybrid CPT programs. And then our services, besides the program application and consultations, we also help students with emergency cases, transfer schools, after reinstatement and stuff like that. We are certified by AIRC as one of the most credible education agencies in America. And then we have two ongoing projects. One is our reward program. So if you're enrolled into a day one CPT school, you can complete all of these activities, helping out your fellow students to earn points and then claim gifts from that. And then we also have sessions just like this every week. So we try to invite industry expert, career expert, DSOs from schools, Day One CPT University to join us to share more free information to you guys. So definitely stay tuned with goelite.com/events. And then if you're not sure who we are, what we do, you can definitely check us out on Google reviews. If you're interested in Day One CPT also, check what other students has mentioned about Go Elite. And without further ado, here are all of the socials that you can find us at. But I will go ahead and stop sharing, and then Marta, you can start with today's topic.
All right, thank you, Ryan. Right, let me share my screen first. Okay, can you see my slides? Okay, great. So this is today's topic. Before we start, I'm going to do a little bit disclaimer. Okay, so for today's presentation, it's educational only. So it's not intended to be legal advice. Even I answer your questions at the end of the session, it's still going to be based on general information. So do not consider as legal advice on your specific case. And for today's presentation, I know it's going to be uploaded onto probably the Go Elite YouTube channel. Please do not share, any video clips or any slides without consent from me on social media or with a third party. So it's intended to be just general educational purpose only, and we don't want to take any piece out of its context. All right. Okay, this is about me. As mentioned, I have been practicing immigration law for 13 years. I am a certified specialist by the California Bar in immigration law. So what I deal with the most is work visas and all kinds of employment-based immigration. We also deal with a lot of F1 status issues, just because a lot of the work visas, such as H1Bs, are for beneficiaries who are currently in F1 status. So if you have questions related to the beneficiary owner, H1B, or other work visa related questions, feel free to leave that in the Q&A. We're gonna prioritize the questions related to today's topic, but if we have some time left, we might get to some other related questions as well. Okay. So, all right. So this is what we're going to cover today. We're going to talk about this. I may have, I may should have put the quotation mark around it because, it's not technically like just like self-employment. It's not like I can just file as an individual. I still have to file the petitions through an entity. So that entity is separate from me as an individual. So that's kind of like the basic concept of H1B. We still have to file through an entity. Okay, and what's the difference between the new rule versus the rule before this new modernization rule, and where to start and how that's different? I saw some of the questions in the Q&A. Those are great questions. So I think someone was asking about how's this different from the regular H1B. Just from the procedure perspective, there's really no difference. All the steps are the same. So in a regular H1B, you file on the I-129 form. Same for this beneficiary owner H1B. You still file that on the I-129 form. And in regular H1B, you have to file the LCA. You still have to file the LCA. And all the fees and all the processing time are the same. So then what's the difference? Well, this is a big difference. It's about the ownership. So before the 2025 H1B modernization rule, usually beneficiaries are not supposed to own more than 50% shares in the company. I know some people managed to do that even before the modernization rule came out. They had to structure it very carefully. Usually that would involve some sort of like board, like overseeing the work of the owner, right? So it involved more planning and more structured design before this rule came out. But after the modernization rule, the H1B beneficiary can own more than 50% shares in the company. And that is not a problem anymore. And you don't even need to have like an additional board or independent advisor or something to oversee the work of the beneficiary. You can just be the more than 50% shareholder in the company. You can be the sole shareholder in the company. You can be the majority shareholder in the company. And you can still be able to file an H1B for yourself through that company. So that is a big difference for the beneficiary owner petitions, especially for a lot of the H1B beneficiaries. At some point, as they want to start their own business, and at the beginning, they might not have those external investors, or they don't plan to partner with somebody, and this gives them a lot more flexibility to do it. So you can just start your own company and be the sole owner in the company and still get H1B through it. So that's the big difference. Okay. And here are some restrictions. The biggest restriction is how much time you get from this H1B approval. So usually H1B is approved for a 3-year increment. Right? You first approval 3 years, and then at the end of the 3 year, you can file for extension, and that's going to give you another 3 years. Or at any point, if you change employer, then you're going to get a new 3 years from the date of the transfer. So that's how it works. But if you are the majority shareholder in the company, at least for the first two filings, you're only going to be approved for 18 months. So half of the time you would have got otherwise. Basically, that is designed as a way to check the status of the business with more frequency than with the regular like H1B petitioner. But it doesn't affect the maximum time you can get under H1B. We know that is 6 years, right? If someone gets H1B status, they can work in H1B status for up to 6 years, and that is extendable. So if the person has I-140 approved by the end of the 6th year, or they have like I-140 or perm pending for more than like a year, 365 days, they can even extend beyond the 6th year. So those rules still apply. So there's no change there. It's just that you will have to file extension sooner than the regular H1B. So that's the difference. Okay. All right. And as for those beneficiary owner cases, that's also a great benefit. You can do things other than the specialty occupation duties. What are the specialty occupation duties? Let's say if you are an accountant, you are starting your own CPA firm. Let's say that's pretty common, like for a lot of the professionals, like if you start a new business, you don't really have to hire a lot of people as long as you're a licensed CPA, right? And you want to start your own business, you can do that. For lawyers too, right? Like lawyers can start a law firm, or engineers to start engineering firm, or maybe for some software developer, they want to start their own software engineering companies. So you can do that. But if you're the only person in the business, that means you probably have to deal with a lot of other like day-to-day like operation tasks. So in the past, those tasks can also raise issues with USCIS. Like the USCIS may question like, are you still performing the so-called specialty occupation duties? Because if your H1B is filed for an accountant position, you're supposed to work as an accountant. If USCIS comes and find, oh, you're receiving mail for the company, right? They might question whether you're still performing the specialty occupation duties. So that is a problem. But we know if you are also the founder, the majority owner in the company, and this is a startup company, you would have to be involved in a lot of those administrative tasks. So the good thing about this rule is it recognizes the fact that a lot of the startup owners have to be involved in those administrative tasks or some of the business development tasks like you have to meet with clients, sign agreements. As long as you can prove that more than half of the time is spent on those specialty occupation duties, that's fine. So even though you are involved in those non-specialty occupation duties, like talking to the client, receiving the mail of the company, that doesn't jeopardize your H1B. That doesn't jeopardize your status. So that is also good news for this purpose. Founders do not have to worry about you're not performing the specialty occupation 100% of the time. Okay, and for the lottery, you cannot just bypass the lottery because for most of the companies that are filing the beneficiary owner H1B petitions, they're still for-profit companies. So they're not qualifying for the cap exemption. You still have to go through the lottery if you have never won the H1B lottery before. However, if you have been counted toward the H1B cap already, which means you've won the lottery before and you haven't used up your 6 years for the H1B status, then this petition won't be subject to the cap again. So basically, it's the same just as any other H1Bs. So the rule is the same for other H1Bs too, right? Like if the company you are working for has like not just an H1B company you work for, like you're working for this company, or you got this offer from this company, and you've never held H1B status before, then you would just have to go through the lottery once. But if you won the lottery before and you got another offer, then you can change employer without being counted toward the cap again. So the same rule applies to this beneficiary owner H1Bs. No difference here. It's just like any other company filing H1B petition for you. Okay. All right. And the key here is because it sounds really good, except that the time you get would be half of the regular time, but everything sounds really good. Then does that mean there would be no restrictions at all? Is there any requirement about how much revenue the company has to generate, right? Like how many people this company has to hire, or any other requirement? No, there's no such, like a fixed amount the company has to make, or a fixed number of employees the company has to hire. No, but doesn't mean there's no requirement at all. And the most important thing you need to prove is the so-called bona fide job offer. We need to show that there is a real job offer there. Basically, the company does have the need to hire someone to perform this role. So you have all kinds of ways to perform that. For example, do you have a solid business plan? How are you going to do your business? Because right now you are a founder, you are an owner in the company. How are you going to run your business? You kind of have to do a little bit pitch to USCIS, just like how you're going to pitch the investor. The concept is pretty similar. You need to let the USCIS officer know what you're going to do, how you're going to do it, and to show that your plan is a viable plan. It doesn't mean like it's gonna be implemented 100% as how it's planned, because when it's put into reality, things will change. That's understandable. But at least at the time of filing, it should look like this is something doable, right? Like you do have the resources to make it work. So I would say it really depends. So in reality, we have seen companies where the founder, ideally, the founder has already had some interested investors who are willing to invest, or who has already invested. Then that's great. That's really good information to show, this is a company that is very promising. External investors has already invested. So that's one way. Or you may not have external investors, but you have interested clients. Like some clients, they are interested in getting either the product or service from this company. Of course, before you start working for the company, if you're currently, like, say, in H1B status with another company, you're not supposed to work for this company until you file the H1 petition. That is really the key. You shouldn't be start working before you file the petition. But you might have already had some connections and they're interested. So that's also a possibility. Or you haven't really got any investor, any interested big clients yet, but you have a really good idea of how you're gonna do your business and you have made some initial investment into the company. That's also possible. As to the initial investment amount, there's no magic number either. It depends on what kind of service you provide, what kind of product you provide. So it's case by case. But overall, we need to show USCIS this is a real job, this is a real business, it's viable. That is the key. Okay. And we still need to show the specialty occupation. I would say in most of the cases we've seen, it kind of makes more sense if the owner is the one who would be performing the service, of the company. What I mean is, for example, for a lot of the service providers, going back to the example we just talked about, accounting firms, right? It kind of makes sense that the owner is an accountant, him or herself. That means even without hiring anybody else, just by yourself, you can show there's specialty occupation work because as an accounting firm, you must need like an accountant to perform the job, right? So that kind of makes sense. Same to other roles like architectural firm, right? Or engineering firm. If you're an architect yourself, you're an engineer yourself, that there's no doubt about you're gonna perform some specialty occupation duties yourself. Things can get a little tricky if you're gonna start a business and your role in the company is sort of a supporting role and you don't have any other employee yet. For example, if you are gonna start a business, I don't know, like e-commerce, okay, and your role is an accountant, that doesn't quite make sense. It can have both problem with specialty occupation or the bona fide job offer. So they kind of overlap sometimes. Like for example, if you are starting an e-commerce job and you work as an accountant, then the question is who's going to do the work of the e-commerce, right? So those are the questions we need to answer and kind of make sense of. Otherwise, you would still have the bona fide job offer issue, and we could also run into the specialty occupation issue. So again, specialty occupation issue is not an issue specific to the beneficiary owner petitions. It's also an issue to all kinds of H1B petitions. Basically, we need to show that a bachelor's degree in specific fields is the minimum requirement of the position. So we have to show this still is a very complex, very specialized position that meet the H1B requirement. Okay, site visits. Again, this is not for beneficiary owner cases only. It applied to all the H1B petitions. We know these days, more and more, there are physical like site visits from DHS. So during those site visits, DHS is going to check whether you are performing the role that you're supposed to perform. That also is a reminder to everybody that when you are doing the job duties, be very careful of the duties you put down because that's what the DHS is going to look at, not only at the time of adjudicating your petition, but also at the time of physical site visits. So they're going to look at the job duties you put down and check what you actually do against that list. So as we mentioned, for beneficiary owners, you actually can do things other than the specialty occupation alone. So if you're going to be involved in some other, administrative, business development duties, make sure you also mention them. So at the time of the site visit, it doesn't look like you're doing things like completely different from what you put down. Be very careful that you want to truthfully state what you're going to do in the H1B petition. And this is something a little tricky because a lot of the people are gonna ask, okay, because I'm the owner of the company. So, like saying in a lot of the registration paperwork, I am the CEO of the company, right? But let's say I'm also a software engineer, I'm also an accountant, what wage level should I pay myself? Should I pay myself as a software engineer or like accountant, or should I pay myself as a CEO? There's a big difference there, right? We know the prevailing wage for CEO is much higher than accountant and software engineer. Like basically most of the professional jobs, the CEO has a much higher wage level. So if you're paid like at that level, it's a pretty a big burden to a lot of startups for the owner to get paid that high wage because a lot of times like the founders they want to you make the best use of the funds. They want to develop the company instead like paying themselves a really high salary. Well, I would say this is a very case specific question. So you need to really review this carefully with the attorney or whoever working on the petition for you because the just because this is a beneficiary owner petition, it doesn't relieve you from all these wage requirements imposed by the government. So technically, if somebody is doing both A and B, that is a combination of occupation. And when there's combination of occupation, the higher wage level should apply. So if you want to argue that, okay, I don't think the CEO wage level applies to my case, you need to have really good documentation to explain why. Okay, for example, one reason could be like it's just myself, even though I have the CEO title, right? But I don't really perform the duties as like a typical CEO duty. It's not like I am managing like a Fortune 500 company as a CEO. There are people reporting to me. I'm the CEO of myself, which is an accountant. So I'm basically just still working as an accountant, right? So you might need to create these good documentation to explain why the current wage level is justified. Otherwise, there could still be a problem of wage violation. And if it's determined by the government that there is a wage violation, that means you are no longer in a lawful status. So there's a pretty severe consequence to that. So do pay attention to that. And since last year, we know the current administration is starting to implement something called Project Firewall. So that is a project initiated by the Department of Labor, and they're going to work hand in hand with Department of Homeland Security together just to do more checks on H1B compliance. And a big portion of H1B compliance is wage compliance. Again, those startup companies, these beneficiary owner petitions, they still have to comply with the H1B wage requirements. So this is something you want to keep in mind. Okay, and from April the 1st, 2026, this year, basically, we know the Form I-129 for H1B has added some more questions. Okay, some of the questions, we had to answer that anyway in the past, such as the SOC code. When we file the LCA, we have to report what SOC code it belongs to. But for the other questions, those questions are not something traditionally asked in the H1B forms, such as what is the level of education? Well, you kind of like mention it in the petition letter, but it wasn't collected in the form itself. And also fields of study, years of experience required to perform the role, special skills required, or is there any person you're going to be supervising? So those are all relevant to determine the wage level. So in the past, H1B sort of got a leeway about, about like how the wage level is determined. You kind of have to volunteer those information as the employer in the petition, but without the form collecting those information, it was really hard for the government to determine what is the appropriate wage level. These questions are very common in the labor certification application, which is, the perm application. In the perm application, employers have to disclose all of these in the form, and the Department of Labor would decide what is appropriate wage level for the case. So basically, the H1B is now mirroring all these questions in the perm application forms. This is to make sure the employer is using the correct wage level in the case. Even this is a small company, even though this is a startup and this is beneficiary owner case, but again, the wage compliance requirements still apply. So be very careful with those questions when you file the form. And then also, it's not just for your own case, whatever you put down, right, for whatever position or for other positions, because I also saw questions from attendees about what if my company starts to petition others for H1B. You also have to answer those questions. So that's kind of like your company's internal record you need to maintain. It should be very consistent, right? So for software developers, if you're a software developer, you hire more software developer, you cannot just change requirement from one person to another without justification, right? So if you start running a business, you really need to make sure you are running the business with all these compliance requirements in mind. So that's also something you want to keep in mind. Okay, yeah. So this is about how you can do a consistency check about your own company's record, making sure all these wage levels and all these job requirements they are consistent across the organization. Okay, so that's pretty much an overview of the H1B beneficiary owner petitions. I hope I can explain some of the questions already, and I'd be happy to take more questions.
Thank you so much, Marta. This is highly educational and informative. And then I especially like the last part where you share some of the updates. I personally find out that's very helpful because immigration and USCIS are changing throughout the whole time, and then a lot of the students are not keep in the loop. So those are highly beneficial. And Shama has already collected some questions from today's audience. We're going to go through them one by one, hopefully have more question answers as we could. And then you guys in the audience, if you do have questions, please submit it to the Q&A box, and then we will kind of pick the right question to ask attorney, and then hopefully that will favor everybody in the audience. So let's jump into question number one. So is this, I assume this is the self-sponsor H1B. Is this still subject to a cap, which were 65,000 registrations?
Right. As we mentioned when we were going over the slides, if you've never won the H1B lottery in the past, then this petition would be still subject to the cap.
Sounds good. Next one, this person is a more ask some more personal questions. Is there anything um, mm, related to self-sponsorship that could be done with somebody in the pilot field, like a flight instructor, or career related to that?
I would say it really depends. It's hard to ask, like answer this question without the context. Like say, for example, what does the employer do, right? Is the employer a school that teaching people to, be pilot? So if that's the case, yeah, like there might be some of the positions that can be H1B like eligible, but it's very case specific. I think for this kind of question, we need to look at the specific case facts.
Yeah, still, I think this is the right question to ask, right? If you're going to spell self-sponsor you, as we mentioned in the presentations, like an entity is unavoidable. So you could start from thinking about what kind of entity could fit in these scenarios. And then as an example that Marta have given is a pretty good example, but you could do a little bit more research on that side as well. So moving forward, next question. I am a civil engineer, graduated in my home country and I have finished my degree here in the US. I'm an OPT, working as a structural engineer, and I wanted to know my chance of getting H1B visa this year. My OPT is actually ending in this year. So again, I will leave the stage to you, but before you go ahead and answer these questions, I think this will be very relevant to a wage level questions. So that would depend on this person's a lot of details, but Marta, what do you think about this situation?
Yeah, I'm not sure if the um this attendee has only like an associate degree or also has other degrees, like other bachelor or even master's degree. The biggest issue here is like I think the degree. Like if the employee, like the H1B beneficiary, has the right qualification. If you're currently working as a structure engineer, I kind of assume the person should have some sort of bachelor degree, but it seems like not currently clarified. So that's the first thing I would check, like whether you have a qualifying degree. If you do have a qualifying degree, then yeah, I don't see why you cannot, at least participate in the lottery, as long as your employer is willing to register for you.
Mhm. Absolutely. And when it comes to chance, I don't know if we talked about this in today's presentations regarding the wage level. But Marta, do you want to give everybody a brief introduction of how the wage level work?
Oh, you mean the weighted selection?
That's right. Yeah.
Okay. Yeah. So for this year, we know that USCIS is gonna do the lottery in a way different from the past years. So in previous years, the lottery was purely random. Nothing really matters. Well, one thing matters. If you have a US advanced degree, then you have another 20,000 quota. So a cap of 20,000 is reserved separately from the regular cap for those who have US advanced degrees. That is still the case this year. So for those who hold US advanced degree, you still get some extra quota that you can be participating in for the lottery. But other than that, it's no longer a purely random lottery. The wage level matters. So for each position, there are four wage levels. Level four is the highest, level one is the lowest, and they're going to be weighted differently. Basically, level four would be weighted four times than level one. So with each level up, your chance would double. Basically, that is how it works. Yeah, so that's how it's gonna be working. But it doesn't mean that the level one wage participants have no chance anymore. It's still like those of higher wage levels gonna be weighted more, but they still need to be selected through the random lottery. So it's kind of like, the raffle ticket you get. Like level one get one raffle ticket. Level four get four raffle ticket. So statistically speaking, those who have four raffle tickets should have a higher chance to be picked, right? But in reality, who knows? Maybe the one with one raffle ticket is just super lucky and gets selected, and not the one with four raffle tickets. That's still statistically possible. So that's how it's gonna be done this year. As long as the company is willing to offer at least the entry level wage, like the level one wage, the person can still participate in this year's lottery.
Absolutely. I love the example. It's very clear compared to a lottery tickets. So let's moving forward. This person have a little bit of concern about what if I have 100% ownership of this company that I'm going to sponsor myself?
That's totally fine under the current H1B modernization rule. Not a problem anymore.
Okay, sounds good. Next one, what could be the minimum shareholding requirement? Like we just talk about 100%, but what would be the minimum requirement?
Well, you can hold any amount of shares in the company. The difference is if you have more than 50% shares in the company, then it's a different type, which is we call it the beneficiary owner uh, petition. And then you're gonna be approved only for 18 months, not for the 3 years, the 36 months as a regular H1B petition. But if let's say you are a minority shareholder in a company, you can still petition through this company, actually. It's just because, you know, we are talking about the beneficiary owner who are as majority owners, doesn't mean as minority owners you cannot petition anymore. Just because minority owners has always been able to get these H1B petition approved, but it was more problematic for the majority owners of the company. So that's why we're focusing on the majority owners. But if you're the minority owner, not a problem. And if you file through the company, you can even get a full 3 year petition, not just like an 18-month petition.
Absolutely. And then this is kind of just like a traditional chicken and egg problem that sometimes when we're so dive into this topic, we kind of forgot you don't even have to be an owner, but you can still petition for H1B under any companies as long as they're eligible. So moving forward, the next question is, can I find an LLC in the US as a student? We actually got these questions a lot. And then, or do I have to wait it actually until I have the H1B to be an owner?
Right. So I would say the safest time to form is probably OPT time when you have unrestricted work authorization, right? Whether you're forming it during like F1 or the H1B status, you need to be very careful because merely forming an entity is not barred, but what do you do with the entity is another question. Let's say you are just forming it, you're doing nothing about it, that's fine. Or if you are part of an LLC and you are truly a passive investor, that's also okay. But if you are actively managing the company, then if you're in H1B status, you would have to file an H1B petition through that entity. You cannot be working for company A while forming a company B and still working for the company B. If you work for multiple companies, then each company have to petition you for the H1B. Or if you're not in OPT status yet, you're still like a student in school, then you're also not supposed to be operating any business. That then can be considered working, and that would be considered a violation of status.
Absolutely. Moving forward, this question, I think the first part is majorly covered, but we can delve into the second part. Does the LLC that I opened need to have any net worth or revenue?
Well, I would say STEM OPT is also a very special period of time. Generally speaking, self-petition is not allowed for STEM OPT. So if you want to do STEM OPT through a company where you have like majority shares, you kind of have to structure it more like how we traditionally structure those H1B like majority shareholder petitions. Like you may need to have a structure where you have a separate board who can create those meaningful and bona fide employer-employee relationship with you, basically meaning you can be fired. So the H1B modernization rule, which allows for the beneficiary, like a majority owner kind of beneficiary, that rule doesn't cover STEM OPT.
Is it related to the training plan of Stan OPT, or is it more related to the E-Verify side of Stan OPT?
That's a great question. It doesn't affect E-Verify. It's not really a matter of E-Verify. The company can still participate in E-Verify program, no problem. It's more about the training plan.
Right. So I assume that you have to have the right person to be able to train you and manage you in a way.
Exactly.
So it's very hard for you to explain that I'm the owner, I'm the founder, and then I'm also the train. You can't be the
You can't train yourself,
trainer
basically.
and trainee yourself, I guess.
Yeah.
That's the paradox. Okay, thank you so much. And then moving on, I am a lawyer and I'm currently waiting for my license, which I expect to receive very soon. I do not have a JD in the US. Oh wow, this is a long question. Let me put that out. Text wrapping. Got it. Um, And due to my background, I'm allowed to sit for the bar. Right now, I work in immigration for a nonprofit, and they mentioned the possibility of an H1B. Would that be possible considering that the salary may be not be at level one prevailing wage, that I do not have much experience yet? I am currently working under OPT as paralegal. So I think the main structure of this question is if I'm not um, yet to hit level one on the wage level, is it possible for me to still petition or even apply for the H1B?
Okay, that's a great question. First of all, congratulations that you are a few days away from receiving your license. That's great. Well, I would say the first question I would ask is, what kind of role are you gonna play within that organization? Because for depending on what kind of nonprofit organization it is, it may not need to hire like an in-house attorney role. So depending on what kind of role they want you to perform, right? What they want you to play, that would determine the wage level. So wage level has a lot to do with the role itself and what SOC code it belongs to. So if your role within that organization is not a lawyer role yet, which kind of makes sense because you haven't received the license yet. So first thing, discuss this role with the organization. And then if they decide, okay, this is the role, then we know like for your area of employment what the level one wage it is, then you have to meet that wage level one because that's the minimum wage requirement for your position. So that like if the employer cannot commit themselves to this level one wage, then they cannot petition you for the H1B. They don't have to pay that right now, but they need to be aware that as soon as the H1B is approved, let's say if this is a nonprofit that's cap exempt, then from the date your H1B status takes effect, it could be earlier than October the 1st, then they have to pay that wage level. Or if they're, also registering you for this year's lottery, then the start date would be October the 1st or the approval date, whichever is later, that's the start date. They have to pay you that rate. So level one wage, there's really no way around it.
Mhm, absolutely. That provides a lot of clarity. I hope that will help you with doing the research and then finding some insights. And then this person does mention that she could be petitioning as a paralegal. So maybe you could check the SOC code if you haven't already do so to see what the level one actually looks like. So moving forward, next question. I'm currently on my final year of Stand OPT as a specialty occupation individual, I'm having issue getting employer to sponsor. What are my other options? So we talked about self-sponsor H1B. For this person, the timeline might be a little bit too tight, but from our perspective, definitely you can consider staying as an F1 student and enroll into a day one CPT school and using CPT. That can allows you to work full time. But Attorney Main, do you have any other suggestions besides the CPT that this person might be able to try within like a shorter frame of time?
Right. I mean, I'm curious, like, where are you working under the STEM OPT? Because clearly, you are working right now, right, in order to maintain your STEM OPT status. So, is there a reason that your employer not willing to sponsor you for the H1B? So that's also something, for most international students, you want to uh, like check, some point way before the registration window starts. You need to know what the company's immigration policy is, whether they sponsor H1B or not. So especially in those cases, if you're in the third year of the H1B, which is the last year, that's very important. You don't want to wait until like March only to find, oh, the company doesn't sponsor H1B or, their policy has changed. So that's something as international student, just to other attendees, you might want to check earlier. But for this attendee, I don't know if it's maybe because the employer has a misunderstanding about the H1B procedure, so they decide not to sponsor you in that way, then you might want to have a talk with them and just educate them a little bit. It's actually a very real situation because a lot of the employers, they are still under the impression that H1B is very costly this year. The employer has to pay 100K to sponsor H1Bs. So they still are under the impression because toward the end of last year, the 100K was still in the news a lot. So some of the employers are still having this myth about H1B. So that can be one of it. That's something you may just clarify through, presenting some of the actual rule on the H1B right now. But other than that, like Ryan said, some other options, including are you gonna consider still continuing the study in the US or do you have spouse to change into another status? Basically, those are the common options
Yeah,
to have.
that's actually a good point. So I assume that everybody in the call, not everyone, are opted in into H1B lottery yet. So if someone is actively doing the persuasion, doing the presentation to their employer right now, how do they break down the fee structure? As you mentioned, 100,000 K is not applicable. If you're in the US, you have a degree, you're under OPT, very likely not applicable to you. But some employers doesn't know that. What are some other information they can share, including how much does the H1B actually cost?
Right. And also for online registration, it's also important to let the employer know like they don't have to immediately commit a lot of filing fees only to find the person's not selected and they lose all the, a couple thousand filing fees from the lottery. So the lottery fee is still pretty affordable to a lot of the employer. It's like $215 per registration. So only after the person is selected, then the employer has to pay for the other like filing fees and etc. So just letting them know at least at this step, it's not that kind of like a big commitment may also help a lot of the employers to like proceed with at least the registration.
Mhm. And besides I'm assuming that filing fee is charged by USCIS, but for example, H1B needs to be submitted through like a lawyer. Does lawyer charge for filing?
Yeah, usually lawyers do charge a fee. That would also vary from firm to firm. But I would say the big portion of the fee, whether that's the government filing fee or the attorney fee, would take place after the registration is selected.
Mhm. Absolutely. That's very clear. I hope that helps somebody who's actually talking to their employer right now. I hope that provides some clarity. Moving forward, next question. What happened when I want to build a company? Can the current H1B visa be transferred to my founder-based H1B later on? This is a good question. We kind of touched on that, but what's your opinion on that?
Yes, that's right. So for this beneficiary owner H1B, sounds like the attendee has already got the H1B status once, right? So you've already been counted toward the cap, you have already won the lottery once, then this transfer would not be subject to the cap anymore. So yeah, you can transfer. But I do need to point out one thing, like you can transfer the H1B to this, like beneficiary owner H1B entity, and you can own more than 50% of the share and still get H1B status through this entity with no problem. But you could still encounter problem at the perm stage if you want to do perm through this beneficiary owner entity. Usually, if you are the majority owner in the company, then it would be quite challenging if you want to do the labor certification, the perm, through this entity. So, but of course, depending on what you do, you may still explore other options, like say EB1A, NIW, which allows like self-petition. But just to want to caution those who want to start their entrepreneurship that you also want to consider the green card part of this. So if you start this and you're the majority owner, you may not be able to get the green card through the employer petition from this company.
Absolutely. That's a good reminder. Next question, can create an LLC during my OPT time? We covered this previously. So technically, yes, but you need to watch out if you are sponsoring yourself, especially under the stand OPT situation. And then second part, how much minimum investment is required to start such a business?
Yeah, that's really case specific. As we said, depends on what kind of business it is, and whether you have other external investors, whether you have some, business that you're gonna sign immediately, and how much would look viable to start a business of that kind. So that's part of the business plan you have to make as part of the documentation to present to USCIS. There's no minimum, but good news is there's no minimum investment amount.
Absolutely. Next one, can someone with an associate degree get an H1B sponsorship?
Yeah, it's still possible, but for those who lack a bachelor's degree, we would have to do some sort of degree evaluation, usually. We have to show, with the combination of, like, say, an associate degree and years of experience that can be considered equivalent to a US bachelor's degree. So that's possible. That's we have done those kind of equivalency evaluation with some of the evaluation agencies in the past to show the qualification of the employee, but merely submitting the associate degree is not sufficient. We have to show still with the combination of degree and experience, it's equivalent to a US degree, like US bachelor's degree.
Mhm. Absolutely. Next question is also what I call it more of a chicken and an egg question problem. So if this person is wondering if my employer doesn't know anything about petitioning in H1B, could I self-petition and tell them to hire me through my own company? I think the paradox with this is that if they hire you through your company, let's treat your company as a consultancy, for example, you still have to transfer your H1B to your company for them to hire you. And then the company still has to go through the H1B petition and application stage. It's just that if you self-petition, maybe you can do the lottery on your own. Maybe you can file for the lottery under your own company. But Marta, what do you think about this?
I would say this is a very creative way to, get the company on board. Um, I feel like this attendee might be asking about some sort of arrangement where the employer doesn't file petition at all. So basically, the company you are currently maybe working for is gonna just enter into this contractual
Right.
agreement with your own company, right? I would say it's permissible. It's not. I don't see anything like legally prohibiting doing this. But just like you are asking something quite different from the company now. So is the company willing to get into that kind of arrangement. But depending on also what do you do, like what your company, your own company, is gonna do. Good thing is like whenever you are making the business plan, your company already has an interested client. That is the current employer, right? But so that's possible. I would say there are still a lot of nuances into it. We need to look into it, but that arrangement itself is not like that's possible, I would say, but just like a lot of nuances are going into it.
Yeah, that's a good point. So instead of hiring an individual, right now the company will hire your company to perform the services. So that's actually a good idea. So definitely, we hope you will follow up with this idea and then come up with a good solution. Next one. So this person has a previous question that might have already been answered. Second part is, will I be subjected to the 18 months approval when I transfer my current H1B to founder-based H1B, or would it be the usual 3 years? Good question. So if I transfer from any other companies, my H1B to my own company, would that be different?
So you're still gonna get the 18 months approval. So when we say the first two are gonna be 18 months, we're talking about the first two from that beneficiary owner H1B employer, not about the first H1B you ever got. So whenever that beneficiary owner company is filing the petition for you, then the first one would be 18 months.
Absolutely. All right. Due to timing's sake, we'll probably do one last questions. And those of you guys, if we couldn't answer your questions, please, you could directly reach out to Marta Mun if you are interested in learning more about self-sponsorship, or if you're interested in more of a CPT or tentative backup plan, you can scan the QR code and talk to Go Elite. Last question would be, I'm on H4 visa. I have filed H1B and approved, but my change status has been denied. Can I apply for change of status to H1B after um, basically apply for again if I get project on H4 EAD. So basically if the person get the H4 EAD, I would look into the reason behind the denial, because if your intention is to file for change of status again, the reason will be very important. But I do want to hear from the attorney. What do you think?
Yeah, I agree. I think the reason of the previous denial is very relevant because usually the change of status portion is denied is that USCIS found out the applicant is no longer maintaining a lawful status in the US. So if that was the reason, and you haven't departed the US or re-entered the US with a different visa, like you're currently in H1B, sorry, H4 status. So I'm not sure like whether you applied for the H4 visa after the last denial. So let's say if the sequence is like your COS denied, and then you left and you applied for H4 visa, and now in the US in H4 status, then yeah, so basically the circumstance has changed. So then the previous denial probably won't affect your current change of status anymore. But if you never left the US after the last COS denial, I would be kind of concerned about the reason of the last denial.
Yeah, absolutely. And no matter what you do, we do encourage you to be extra cautious with your second application, regardless of what reason resulted in the first one. So in that case, if you wanted to speak with the immigration attorney, you can definitely scan the QR code. We can refer you to Marta. And then you could have maybe a consultation or a later on support from her side that you can share more. But definitely, this is I feel like this is an urgent situation. So I hope that we can help you on that side. But I want to thank Attorney Mara Ming for joining us. The presentation was very smooth, informative. This is something we rarely talk about, so thank you for opening the door for us. And also thank you for being so professional and insightful in terms of answering all of the questions. I know that we didn't got to all of the questions, so hopefully we can have you back with us soon to answer all of the questions from the audience. Thank you so much, Marta.
Thank you. Thank you for having me. Thank you, everybody, for attending today's webinar.
Okay, thank you. And then thanks all of you guys for staying tonight to join this session. I hope you enjoyed the session. And then, as I mentioned before, we try to host these kind of sessions every week. So definitely stay tuned for golead.com/events for future events. And then